Hi everyone, I'm Supriya Gill, a licensed lawyer, and today we're going to talk about something really important, the Violence Against Women Act, or VAWA. Specifically, we'll discuss whether you need to be married to qualify for VAWA, what happens if your marriage isn't legally valid, and if people who live together without marriage can still apply. Let's dive in. So what is VAWA? VAWA stands for the Violence Against Women Act. It's a special immigration benefit that helps people who have been abused or faced domestic violence by their U.S. citizen or permanent resident spouse. And don't be fooled by the name. It's not just for women. Men, children, and even parents of abusive U.S. citizens or permanent residents can also apply. Do you need to be married to apply for VAWA? Now, to be eligible for VAWA, you usually need to be married to a U.S. citizen or lawful permanent resident, LPR. But what if you got divorced? You can still apply, but there's a catch. You have to do it within 2 years of your divorce. After that, you lose your chance to apply under VAWA. This same rule applies if your spouse loses or gives up their citizenship or green card. What if you thought you were married, but you weren't? Here's where it gets interesting. Let's say you thought you were married, but later found out the marriage wasn't legal, maybe because your spouse was already married to someone else. Don't worry. If you genuinely believed you were legally married, you might still qualify for VAWA. Proving your marriage was real. When you apply for VAWA, you need to show that your marriage was real, also known as a bona fide marriage. This means you'll have to provide evidence like your marriage certificate, photos from your wedding, joint lease agreements, joint bank accounts, and things like that. But what if you don't have all of this because you've separated from your spouse due to the abuse? That's okay. While photos and documents are helpful, they aren't always required. What if you're living together, but aren't legally married? What if you're living with someone who's a U.S. citizen or permanent resident, but you're not legally married? Maybe you're in a long-term relationship or have a child together, but your partner refuses to get married. Can you still apply for VAWA? The answer depends on where you live. If you live in a state that recognizes common law marriage, like Colorado or Montana, you might be in luck. Common law marriage means that even if you didn't have a formal wedding, the law considers you married because of the way you live together. In these states, USCIS will recognize your relationship as a valid marriage for VAWA. But remember, every state has its own rules about this. For example, Texas provides documents that prove common law marriages, making it easier to show you're in a legal relationship. However, states like Alabama no longer recognize common law marriages, but if your common law marriage was established before they changed the law in 2017, it's still considered valid. What if your marriage turns out to be invalid? Sometimes people find out that their marriage wasn't valid, like if their spouse was still married to someone else when they got married. Normally, this would mean your marriage isn't legally recognized, but VAWA makes an exception. If you genuinely thought you were in a valid marriage and suffered abuse, you can still apply for VAWA as if your marriage was valid. Conclusion. To wrap it up, VAWA is there to protect people who've experienced abuse, even if their marital situation isn't straightforward. Whether you're dealing with a divorce, a common law marriage, or a marriage that wasn't legally valid, VAWA can still help you. The key is to prove that your relationship was real and that you faced abuse. Thank you for watching. I hope this video helps clear up some questions. If you found this information useful, don't forget to like, share, and subscribe for more videos on important legal topics.